I'm Tiffany Lesnik. I'm a licensed attorney and also a survivor of domestic violence. I'm going to share with you my personal and professional experiences to help you change the outcome of your case for good. We've been talking a lot about domestic violence in the law. Today, we are going to talk about when is it legal to record my spouse for court. We have a free gift for you today. It is my guide called Top Lies Abusers Tell. Click on the link below to get a copy of your free guide today. So we have talked about in previous videos, which are available on my YouTube channel as well as at www.livefreelegal.com, and I would encourage you to go back and watch some of those. As we have talked about in some of our prior videos, family law is going to be dependent on the state that you live in. So all statutes for domestic law are going to be different depending on where you live. It is very, very important that you know the statute or you consult with an attorney in your particular state that understands the statute on recordings in your particular state. I'm a North Carolina licensed attorney, and so in my particular state, the laws that govern how you can record someone are not going to be the same as someone who lives in Montana or Virginia or New Hampshire. So I want to preface this recording on this is not legal advice across all 50 states. This is just some general guidance of where to go when it comes to recording your spouse for court. And I would highly encourage you, before you start recording your spouse, that you seek the advice of an attorney or legal representative in your particular state before you begin recording, as it could be illegal or you could be breaking the law if you are recording your spouse without their consent and you don't do further exploration into whether or not it's legal in your particular state. So I would highly encourage you to seek the advice of an attorney before you begin recording if you are in a state outside of North Carolina. So last week we talked about what are some of the types of best evidence that we can use in domestic violence cases. And my number one form of evidence that I love to use in cases involving domestic abuse were audio or video recordings. Now be mindful, there may be differences between an audio versus a video recording. A couple of those differences would be an audio is going to feature people's voices. There's going to be sound, but you may not see the people. Versus a video recording, you're going to actually see imagery, but there may not be audio. So there are differences between those two different media forms, and there may be differences in your state as to whether or not it's legal to use an audio recording versus a video recording. So again, very important to seek the advice of legal counsel in your state to distinguish between the two. There are federal laws that govern recordings, and then there are also state laws that govern recordings. The federal wiretapping laws, which are governed by federal laws, generally only require the consent of one person in order to record them. So as long as you're present during that recording that's taking place, generally that's going to be legal. However, your state laws are going to govern whether or not you can record someone in your particular state. There are one-party consent states, and then there are what we generally refer to as two-party consent states, but they're better called all-party consent states because many of these states require not just the consent of both parties to the recording, but all parties to the recording. Let's say you're in a room that has 5 people, all 5 of those people would have to consent to that recording being made for that recording to be legal. There are 12 states that require, under most circumstances, the consent of all parties to a conversation in order for that conversation to be recorded legally. And those states are California, Connecticut, Florida, Illinois, Maryland, Massachusetts, Michigan, Montana, Nevada, New Hampshire, Pennsylvania, and the state of Washington. Very important if you live in one of those 12 states that you seek legal counsel before you record your spouse or your abuser. If you do not have their consent, recording them in those states could be against the law. If you are in any of the other states that I did not mention, including the District of Columbia, so Washington, D.C., Those states are generally going to be one-party consent states, which means only one person has to consent to the recording in order for that recording to be made. So whether you are on the telephone, you're participating in a conversation on the telephone with that person and you press record while you're on the phone, you are consenting to that recording being made. You're participating in that conversation. You can record that conversation, at least here in North Carolina you can, and then in the majority of the one-party consent states. If you are present in the room, so if you have a recording device and you are in the room with that person and you press record, you are consenting to that recording being made, even if they don't know you're recording them. If you are in a one-party consent state, then you legally can record them if they do not know that you're doing so, as long as you are also present when the recording is being made. Now, this does not apply to, I'm going to purchase a recording device and I'm going to put it in my spouse's car and I'm going to record whatever they're doing while they're driving. That is not legal. You're not in the car with him at the time the recording is being made. It doesn't apply to, I'm going to tap the home. I'm going to put recording devices in our home, cameras, audio devices, things of that nature. And then when I'm not home, I'm at work, I can watch what he's doing. I can see what he's doing. I can hear what he's doing. You are not present at the time that recording is being made, so that would be illegal, even in the one-party consent states. Because even if you're consenting to the recording being made, you're not present when the recording is being made. And so that's a really big deal. You must be present when the recording is being made. There are some really interesting recording devices that are out there now that you can purchase that you can leave and they'll only record whenever there is noise. I would caution you that if you have such a recording device, you can get them on Amazon or you can get them on the internet. They're innocuous looking recording devices. They look like USB drives. They can look like pens. They can look like watches. They look like anything, any ordinary household item laying around or technological item laying around, but they don't really look like recording devices. And what they do is they begin recording when they detect noise. And that can be really easy, especially for your abuser, to leave around the house. Maybe leave on the kitchen counter, leave on a desk somewhere, leave on a coffee table or an end table in the living room, leave in your bedroom, that he can record you when he is not home. So just remember that doing that is illegal. That is against the law. If you find a device like that, make sure that you confiscate that device. You certainly could take it into law enforcement and ask about what your rights are. I would encourage you not to do the same thing. So don't purchase those types of devices and then leave them around the home in order to record him, because that is illegal if you are not also present. However, if you are present, that might be a good way to record him so that you're not having a device that you're having to mess with in the middle of a conversation, or if he starts arguing with you or yelling at you and you're really nervous, you're not having to mess with buttons in order to record him. So having a device like a pen or USB or something innocuous that you can leave in the kitchen with you, in the living room with you, in the bedroom with you, if you want to make a recording so that you don't have to worry about pressing buttons, may be a safer way for you to record your abuser. Just remember that once he leaves the room, or once you leave the room, you need to take that device with you so that the recording is legal. A couple tips on recordings. So if you are recording, be mindful of how you sound. If you want to use this recording later in court, you don't want to come across as the initiator, the aggressor. You don't want to come across as abusive. So do not raise your voice, don't yell, don't cuss, don't scream, don't follow him around interrogating him. Can you repeat what you said? Tell me what you said again. What was that? Following him all around the house, making him talk even if he doesn't want to, because then you look like you are the problematic partner in that relationship. You want things to be as genuine and authentic as possible in those recordings. Just be mindful when you're recording yourself of how you sound. There are limitations to recordings if there are third parties involved. So if there are other people present, if there are children present and they're speaking in the recordings, it's possible that if you try to use those recordings in court, that there could be an objection to hearsay because there are other folks present. Be careful with how you record. We don't want to be putting a recording device in his face, like speak to the camera or letting him know that you're recording. Your safety could be at issue by doing that. And we don't want a situation where he's trying to grab the recording device out of your hand or grabbing your phone out of your hand and putting you in harm's way. Be careful of that. It also doesn't look good for you if you're intentionally putting a device up in his face. It makes you look aggressive. Be careful of length. Length can be problematic in timed hearings. So in North Carolina, where I'm from, sometimes we have a hearing that's limited to 1 hour for domestic violence. And so when we're having to split that in half, he gets 30 minutes, my client gets 30 minutes. If she's got a recording that's 20 minutes long, that can take up the bulk of the hearing time. So just be mindful of how long some of these recordings are. Try to get the best of it and then stop the recording so it's just not going on and on. Be mindful that recordings are discoverable. What do I mean by discoverable? If you are in the midst of litigation, so let's say you have filed for a protective order or he has filed a lawsuit against you for divorce or custody, or maybe you filed for custody, child support, property distribution, or alimony, his attorney can issue what we call discovery. So he or she can issue a request for production of documents, and they can ask for you to produce those recordings. So just be mindful when you're making these recordings that you may have to produce those at some point in the future for his attorney. All in all, as an attorney, especially with domestic abuse, when you're dealing with a he said, she said, especially with cases where you have a really charismatic, narcissistic spouse whose appearance out in the general public is much different than they appear at home, or if you have a spouse who within the church presents as this phenomenal believer and he's conned everyone in the church into thinking that you are the spouse with the problem. Recordings can be a wonderful way of really showing your partner's true colors. Even though there's some risk to recordings, I do believe that the benefits outweigh the risk. Again, I encourage you to seek the advice of an attorney in your state before making a recording, because each of the states do have different laws as it relates to audio and video recordings. I have a couple of links that we're going to post for you that gives more information about recordings in the different states. I hope you find those links helpful. I hope that you felt empowered today and that you will join us next Tuesday at 7 p.m. as we explore how to prepare before filing for a protective order. And we hope that you will join us for one of our private Live Free membership groups. We are excited about our Live Free membership launch. Right now, through May 5th, it is only $35 per session for a 12-week session package. We have a limited number of spots available, so click on the link below to get more information about our Live Free Legal 12-session package. Also remember to click on the link below to get your free guide, Top Lies Abusers Tell, and get started on your legal empowerment journey today. And finally, make sure to give us a thumbs up and subscribe to our channel for updates on upcoming videos. Remember, I am a licensed attorney in North Carolina. I cannot offer legal advice outside of North Carolina. The purpose of these videos is to offer general advice, not legal advice, to help you improve your legal outcomes. I would encourage you to seek the advice of an attorney in your area if you need additional help. You were created to live free, not in bondage. Join us next time as we continue to learn more, support one another, and continue to move from fear to freedom.